Good morning and welcome. So today we're going to talk about petition drafting. As Sue mentioned, it's a critical skill for protective services and foster care workers in our child welfare system, but it's a skill that's somewhat easily overlooked. And so what we want to do this morning is spend some time focusing on effective petition drafting. What we're going to do today essentially is we've got sort of 6 things that we want to try to cover this morning. The first of these is we want to talk about the constitutional notice requirement that is available, or a right of children and families in our constitutional democracy. And so we're going to talk about the constitutional right that's at issue when the state of Michigan petitions a court to make a child a court ward and potentially remove that child from the home and maybe even terminate parental rights. And we'll talk about how it is that the petition that you draft fulfills that requirement of constitutional notice. We're going to talk about how petitions frame a case. Lawyers will talk about the framing of a case in a particular way, or how you see the case. Essentially, it will be your argument about why the court should do what it is you're asking the court to do. We're going to talk about the basic legal requirements of a petition, some of the kind of very foundational rules and foundational information that must be contained in every petition that you file, whether it be a petition for temporary custody or a petition for permanent custody. We're going to talk a little bit about what it means to draft an effective a petition for temporary custody, and we'll talk about what it means to draft a petition that's effective for achieving permanent custody if you need to do that. And then we'll talk about some differences between those petitions which are effective and those petitions that are not effective. I want to talk just very briefly about the way we're going to do that. I'm going to provide some lecture this morning and a PowerPoint presentation. A little bit later, we'll have a chance for you to work in small groups at your table in order to critique a petition that was actually filed in a child protection case in Michigan. And then after, we'll have some more lecture, and then after that you'll have an exercise in which you look at a set of facts, and then you at your table will draft a petition. And then we'll look at the petitions that you draft and talk about the strengths and the weaknesses of those. And then I'll give you a copy of the petition, one way that the petition may be drafted by an attorney who might look at that same case. One thing that's really critically important for you to think about as we go through the day today is that we're going to talk about some of the basic rules today. When you go out into the counties in Michigan, there are 83 counties in Michigan. I like to tell people that means that there are 83 different child welfare systems in Michigan. Because effectively, every court does these things a little bit differently. Every DHS office does these things a little bit differently. And so what we're going to try to talk about today are kind of universal concepts. And then when you get to your county, you want to make sure that you understand exactly how your county does it. Because again, each county will do it somewhat differently. Before we actually start in the substance, are there any questions anybody has about what we're going to do today? Okay, great. So I want to start with this idea of how the petition works within the confines of the United States Constitution. This is crucially important that you understand that parents and children have what the courts have called a fundamental right to remain together as a family unit. That is to say that parents have the right to care for their children on a day in and day out basis. They have the right to care, custody, and control of their children, and that children have the right to be associating with their parents, to learn from their parents, to have attachment with their parent on a sort of day-to-day basis in order to ensure their healthy emotional development. This is a right that the courts have determined is fundamental to our society. The family we think of as being the sort of basic building block of society. And it's a right that the courts have found to be part of our constitutional rights. Just like, if you were to get involved with the police and maybe be the focus of a police investigation, you'd have the right to remain silent. That right comes from the Constitution. The right to remain together as a family unit also comes from the Constitution. It's part of the liberty that our Constitution guarantees to each individual citizen. This generally means that each family has a right to integrity, that is to say, a right to remain together, and the right to not have the government interfere in the family's life. So when Protective Services goes out and investigates a situation, what's happening is the state of Michigan's government, through the Protective Services function, is taking some action to involve itself in the private life of a family. And so there are constitutional parameters around what we can do and how we do things. But it's important to understand that this right to familial integrity is not absolute by any stretch of the imagination. Essentially, the courts have decided over and over again that while a family has a right to privacy, to be left alone by the government has a compelling interest, a very significant interest, in protecting children from harm, from abuse and neglect. And so the state is permitted to involve itself or to step in and to intervene in family life when abuse and neglect is present. So what we have then is we have a process. The Constitution requires a certain process in order for the state to do that, to step into a family and to remove a child, or to require a parent to take certain action on behalf of a child, or to refrain from taking certain action on behalf of, with regard to a child. So that the state has to, when it intervenes, make its intervention consistent with what we call due process of law. And due process of law we'll talk about a bit. Does anyone here have any concept of what due process is? Have you ever heard that term before? You have the right. So you have certain rights, which means the government has certain responsibilities with regard to you, right? So if you have a right not to be listed on a governmental database without having been told that that's going on, then the government has a responsibility to notify you when they list you on such a database. And that's why we have to send notice when we list someone on the central registry. Because when when an individual has a right, that means the government has a responsibility. So one kind of effective way of thinking about this comes from this case, from actually a case out of Iowa, which I think really captures the idea of due process quite well, and particularly notice as it relates to due process. It says that due process is an orderly process wherein a person is served notice and has the opportunity to be heard and to enforce and protect his or her rights before a court having the power to determine the case. And so you can see in just this little short paragraph, basically everything that happens in a child protection case up to the time of the adjudication. So it's an orderly process. It's a process that people know about. There are lots of rules. There are court rules that govern this process. There are statutory laws that govern this process about how we go about doing things. When can Protective Services investigate? What are the parameters of a Protective Services investigation? What are the rights of the parent during the investigation? What are the rights of the child during the investigation? We have rules and regulations regarding each of these things. And so the process is orderly. We know what it is. We know what the parameters of that is. That a person is entitled to be served notice. That is, you've got to give notice if you're going to list somebody on the central registry. Before you go to court and ask that the court remove a child from a home, you have to provide the parent notice in the form of a petition. It says exactly what it is that the parent did or didn't do for the child that results in the child either being abused or neglected. the parent has the right to be heard. That's the whole idea of the trial in court, right? It's the parent has the right to be heard by a neutral person, a court that doesn't, it's not on the side of the DHS, a court that's not on the side of the parent, a judge or a referee who is disinterested, doesn't have a position in the case, listens to the evidence and then decides, or a jury may do this, listens to the evidence and then decides whether or not the child has been abused or neglected. And so there's this right to be heard, and then the court, then if the court makes the determination that a child has been abused or neglected, or if the parent admits that, they give the court, that gives the court the authority to make decisions regarding that family's life. Where will the children be placed? When and under what circumstances will the parents visit or see the children or parent their children? What sorts of treatment plans are going to be put in place and required of the parent? What treatment might be necessary for that child, and then that family as a unit. So it's a very orderly process in which there are lots of rules that govern how we handle these cases. Another way that you can think about due process is to think about it as being a question of fundamental fairness, or the idea that you look at something and you say, that's just not fair, right? If you looked at a process and you just said, that's just really not fair, then you could think, well, we haven't done this fundamentally in a way that's fair to the parent, that's fair to the child, or that's fair to the state of Michigan, right? If we could not file petitions in court, then to remove children or to take jurisdiction of children, then you'd say, well, the state of Michigan has this compelling interest in protecting children, but there's no way in which the state can vindicate that interest because we don't have any legal proceeding, any process for the state to be able to step in and protect that child, to take care of that child. And so this idea of fundamental fairness is that when you look at the situation, you should be able to say to yourself, yeah, that is fair. If it's fair, then you're doing things in the right way. It wouldn't be very fair if, say, Roberta was a parent, a mom, and I'm a protective services worker, and I go over and I say, I'm going to take your children from you, but I'm not going to tell you why. That wouldn't be very fair now, would it? It wouldn't be very fair if Roberta didn't have the chance to go before some disinterested judge or individual, someone, to be able to say, look, I didn't do the things that the protective services worker says I did. I'm innocent of this. We wouldn't think of that as being fair. So fundamental fairness is another way to think about this. And when you sort of step back and look at something in the legal process, and you can't say, gee, that really is, it's fair. It's the right way to do things. Then you're sort of talking about a due process issue. So again, legal proceedings that involve the family must be conducted in a way that is fundamentally fair and meets the basic requirements of fairness in our society. That way, this protects people so that you're not removing children for an unfair reason because somebody's just poor, or because somebody is of a different race, or you don't like somebody's religion. Those are the things that we want to prohibit, and we want to have substantive reasons. You abused your child. Even though you are, you have the resources to provide for your children, but you're using your money using it for drugs or drinking excessively rather than providing food, clothing, and shelter for your children. And so we think about this as families having an entitlement to a fair process before removal of their children. So I want to go back to this notion of notice, this idea of legal notice. And notice is a concept that requires that we tell the parent exactly what it is that he or she has done that is abusive or neglectful. You can think about this in a criminal context is another way to think about this. If the state of Michigan says that somebody committed a crime, they have to say exactly what crime it is that they committed. you're charged with assault and battery, or you're charged with drunk driving, you're charged with murder. Whatever the crime might be, you have to put it in writing. You have to provide notice to the party about what it is that the state of Michigan says that you did wrong. Notice is a part of this notion of due process, right? So again, putting things in writing and giving parents and children specific notice of what it is that we claim is the root of the abuse or neglect is part of that idea of being fair, so that the parent has the right to come in, the opportunity to come into the court and to say to the judge, I didn't do this thing that I'm charged with, that they allege, or these facts are inaccurate. My house isn't a mess. I don't use drugs. Or I use drugs, but it doesn't impact my children and my ability to care for my children. So this idea of notice is part and parcel of that idea of due process of law and fundamental fairness. So the United States Supreme Court has ruled that notice, in order to comply with due process, must state set forth the alleged misconduct with particularity. So it wouldn't be enough if we said, Mrs. Smith abused her daughter. It wouldn't be enough if we said, Mr. Smith neglected his son. That's not sufficient. It's not proper notice because it's not particular enough. We have to say what exactly it is that the parent did. Mr. Smith abused his son by striking him in the face and giving him a black eye, right? Mrs. Smith uses drugs, and as a result of her excessive drug use, she's not able to provide adequate food, clothing, shelter for her children. It's also crucial that this notice be in writing. So it's not enough that we just say it, or that it's that we tell people what it is that they did. We have to put it in writing, and that way they have a copy of it. They have a copy of it in front of them. The petition that we're going to work on, the petition that you file, whether it be a petition for temporary custody or a petition for permanent custody, fulfills the notice requirement because it puts in writing, specifically with particularity, each of the allegations of abuse or neglect that we make against a parent. It also makes a specific request of the court. The petition asks the court to take some action. Remove the child from the home. Maybe instead of removing the child from the home, you're asking the court to remove mom's boyfriend who abused or neglected the children from the home. Maybe you're asking the court to terminate the parent's rights. Perhaps you're asking the court to make the children wards of the court, but leave them with the family while the parent works on a treatment plan. Any of those things is a possible request or a prayer for relief in a petition. And so we make specific factual allegations about what it is. And we also have to provide specific reference to a legal provision or a provision of the law, right? So probably if you've got much experience at all, you've had a chance to look at the Juvenile Code, Section 2B, which forms the basis for the court's ability to take jurisdiction of children. That provision that says that the parent fails to provide adequate food, clothing, shelter, the parent neglects, the parent has engaged in behavior that's depraved, those kinds of things. The parent is engaged in criminality. That Section 2B is the basis for all court jurisdiction in child protection cases. And so you would cite that provision of law. And most specifically, which provision within 2B you're sort of focused on, or that you think that the case warrants the court to get involved based upon. So you have a specific factual allegations, and you've got a legal allegation, right? Mrs. Smith, the Smith children come within the provisions of Section 2B of the Juvenile Code. That's the legal provision. Specifically, Mrs. Smith is a substance abuser. She uses drugs and alcohol excessively. She cannot take care of her children. The kids don't have adequate food. Because of the mother's drug use, she can't maintain an adequate home, and so on and so forth. So again, specificity both in terms of the factual allegations in this particular case, and specificity in terms of the statutory reason for why you're asking the court to intervene in the case. So we get this kind of thing. So Amanda Jones comes within the provisions of Section 712A.2A and B, in that on March 18th, 2008, today, Betty Jones, Amanda's mother, shook her violently, causing injuries to Amanda's brain. There can be no real question there what it is that you're asking the court to do, right? Or at least what you allege that the mother has done. The allegation is made specifically, it's made clearly, there's no question about it, and you have a citation to the statute. Now, a lawyer might look at this and say, well, Section 2A and B, they have lots of sort of parts, right? Are you saying that the mother's depraved? Are you saying that the mother's abusive, neglectful, that sort of thing? An enterprising lawyer might come to the court and say, look, this isn't enough specificity. They have to give us the specific provision of the law, the specific thing that we have to defend, because it would be unfair. It would violate due process if we didn't know exactly what the claim is that we have to, sort of confront in court. But I think that provision is clear enough that the court would say, look, you understand the allegation. The allegation is clear. It's that Mrs. Jones shook the child and injured her brain as a result. If the petition alleges only vague facts, any attorney can seek to have that clarified by the court. So, for example, Bo Jones, Amanda Jones's father, has neglected Amanda Jones. How is that different than the allegation we just had about the mother? Can anybody see the difference?
There's no action indicated.
That's right. There's no action, or there's no failure to act in a neglect case, right? So the mother doesn't really know, mom's lawyer doesn't really know, dad's lawyer doesn't really know. What is it that Mr. Jones did or didn't do exactly? I mean, neglect can be any number of things, right? So what you want to say is what? How could you clarify this?
As evidenced by, and then you have your list.
Okay, so as evidenced by, number one, his failure to protect the baby from mom shaking, right? So if it's a shaken baby case. Or you could say Mr. Jones failed to provide proper food, clothing, and shelter because he's not paid his child support in X amount of time, and as a result, the child's not had the benefit of financial support from her father. Okay? So again, specificity is always going to be better when you're writing petitions. So now what I want to do is talk a little bit about how the petition frames the case. Lawyers and legal people will talk about framing a case in a particular way, so that what essentially would happen is, you have a set of facts. Here's a set of facts. Mrs. Jones shook Amanda, causing her brain, shaken baby syndrome, her brain to be injured. Mr. Jones was present. Mr. Jones had seen mom do this in the past and didn't intervene and stop it, didn't protect the child from mom's shaking. Let's say those are the basic facts. Lawyers will talk about framing that case, right? So the agency, you're framing this as a child abuse case on the mom's part, and it's framed as a failure to protect case, a neglect case relative to the dad. So you can sort of think about things as being framed in a different way. Mom's lawyer might say, might frame that case in a completely different way. Mom's lawyer might say, indeed, it was dad who shook the baby, and mom had no knowledge of this. In fact, he did it while she was at work, right? That might be one way that mom's lawyer might frame the case. The child's lawyer might frame the case completely differently than either of those and say, it doesn't matter. It doesn't matter whether mom did it or dad did it. The problem is the baby got shaken by one of these two folks who either did it or failed to protect the baby from it, and the court has jurisdiction regardless of which of them did it. Okay? So you can see that you can take a particular set of facts and look at it from different perspectives, and you have different framing, as we would say, of that issue. And so what we want to do then is we want to think about how the petition frames how you think about your case. And I want to start that with, again, referring back to Section 2 of the Michigan Juvenile Code. This is the provision of the law which grants the family court jurisdiction over children in child abuse and neglect cases. And we'll take just a second and read this. So jurisdictional provision, Section 2, states that a parent who neglects or refuses to provide proper or necessary care, support, education, medical, surgical, or other care necessary for the child's health or morals, who is subject to substantial risk of harm to his or her mental well-being, or who is abandoned by his or her parents, or who is without proper custody and guardianship. Just as this gentleman here in the middle of the room mentioned earlier, notice that each of those provisions is very broad, right? It's very subjective. What does it mean to not provide proper or necessary support? I mean, we can debate that, can't we? It's not entirely certain what that means. What does it mean to not provide proper education for a child? What does it mean to not provide proper medical or surgical care for a child? Perhaps the parent and the doctors just disagree about what medical care is appropriate and correct. Once in a while you'll get involved in a case where a child's terminally ill and or has some serious medical condition, and the parent disagrees with the medical providers about how that should be handled. Mom and dad might say, look, we've been through enough of this. We want to stop this. Our child has been ill for a long time, and we just want nature to take its course. The doctors might, on the other hand, say, look, there's treatment that's still available. We haven't tried everything yet. We want to allow this child to have additional treatments so that perhaps he or she can recover. So we get into a question then maybe of who makes that decision, right? Is that neglect, or is that an appropriate decision made by a parent about medical care for his or her child? And so you see that these are written in a kind of very broad and general sense. Let's look at the other one. This is from paragraph B of Section 2 of the Juvenile Code. So the court has jurisdiction over a child whose home or environment, by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent, guardian, or non-parent adult, or other custodian, is an unfit place for the juvenile to live. So again, you see very broad, kind of general provisions that allow the court to take wardship of a child, to protect a child, and to issue orders regarding that child's care, custody, and treatment. So why do we have these really broad kind of jurisdictional bases, or these laws that let the court get involved in any kind of case if the court deems it appropriate? First of all, because the legislature couldn't anticipate all of the ways that you encounter in your work that a parent might abuse or neglect a child, right? So if the legislature passed a law that said parents shall not punch their children, for example, then the question would become, well, Mrs. Jones, remember she shook the baby. She didn't punch the baby. That doesn't come within the law, so the court's powerless to do anything about that. That might be a good argument, right? The legislature can't anticipate everything that a parent might do or fail to do. I mean, some of these things, I'm sure those of you, I understand a lot of you are experienced and some of you are less experienced, but if you've been in this business for a while, you will come to it will boggle your mind the ways in which parents find to harm their children. You know, who in the legislature would imagine that a parent might take a cigarette and intentionally burn his child repeatedly? You know, that happens from time to time. So the legislature wants to give the Department of Human Services and courts a good bit of discretion in protecting children. Okay? We want to set a fairly high standard for child care. Not a standard that's unreachable by any means, but we want to have you know, kids get at least a minimal quality of care. And in order to protect kids from the array of harms that might befall them, the courts have to have discretion, have to have latitude, and the agency has to have latitude. You guys need latitude when you're out in the field and working on a case. And so the statute's written in sort of broad, even subjective language. There's a subjective element to all of this. But when you file the petition, you have to write that with specificity. What exactly is it that the mother or that the father did that you claim constitutes criminality so that it makes the home an unfit place for this child to live? A couple of years ago, we had a case, Michigan Court of Appeals decided, in which a father was charged criminally with killing his wife. And the agency filed a petition to protect the children, to take jurisdiction of the children, and to place the children with relatives. The question was, that was unclear was, is it quote-unquote criminality if the parent's never been convicted of a crime? Because the father had been charged, but he had never been convicted. And so the question really was, what does this term criminality mean? The Michigan Court of Appeals ultimately said that criminality includes being charged with the sort of crime that this father was charged with. That may not mean that every crime that a parent might be charged with. You know, you could have a parent who's, for example, charged with maybe drunk driving or, you know, assault and battery on a coworker. That might not make the home environment an unfit place for that child. Parent might well have assaulted a coworker, but still be an entirely fit parent. Might have gotten into a fist fight at Tiger Stadium, but be a perfectly fine parent. And so the petition requires that there be specificity with regard to what it is that you allege in this particular case. What is it that Mr. and Mrs. Jones or Mr. and Mrs. Smith did or didn't do that's specific in this case? So the petition, by requiring specificity, establishes the parameters of what the case is going to be about, right? So this case is about a parent who shook a child, physically assaulted that child, which resulted in the child having a serious brain injury, right? Typical shaken baby case. So the petition draws parameters around the case. And if it's not addressed in your petition, then it's not going to be available for the court to take jurisdiction on that basis. So if the petition does not allege that, let's take our Jones petition, right? So mom shook the baby, dad failed to protect the baby. If that's the only allegation in the petition, then when you come to disposition, you're going to have a hard time if the issue is drugs, right, or alcohol use. Maybe what you think happened is mom was high at the time, right? Mom was high, the baby was screaming for a long time, she lost her temper, she shook the baby, baby's seriously injured. Maybe your allegation is mom was not high, but dad was drunk at the time, and he drinks too much, and he leaves mom all the responsibility of taking care of the baby, and mom's at her wit's end with the baby, and dad's not available because he's drinking too much. So you've got, again, abuse on mom's part, neglect on dad's part, but an underlying issue is alcohol. You want to make that allegation in your petition, because if you haven't made your allegation in the petition, come disposition, the court's going to be unlikely to order services to address that problem. Yes? Okay, so let me see if I understand your question. So you filed a petition in which you've alleged,
Yes,
Protective Services filed a petition in which there was abuse and alcohol use or drug abuse was alleged. As part of a plea agreement, they took the substance abuse out of the petition and the parent pled to abuse or neglect of the child. And now later on, you're at a point where you may want to seek termination of parental rights, and you want to allege that the substance abuse is a part of the problem and why the court should terminate. What do you do about that circumstance? A couple of things. One is, if you allege that in the neglect in the termination petition that mom has a substance abuse problem or dad has a substance abuse problem, and that contributes to their incapacity to take care of their children and is a reason why the court should terminate, you can do that in the termination petition, but you're going to have to prove that.
prior to the filing of the termination.
Well, as part of the termination hearing. So you're going to have to prove that. That's what we would call a new allegation, and we'll talk about that in a little bit. But that's a different allegation. If you throw an allegation out, then you bring that allegation back in a termination petition later on in a supplemental process. Then you're going to have to prove that with legally admissible evidence at a higher level, clear and convincing evidence. Then you would have to prove it originally in a temporary custody petition. So it can be done. It's going to be more difficult. So the question is, what do we do about plea bargaining? And we're going to talk about that in a little bit when we're going to talk about some strategies when you're thinking about your petition. But it's one important thing to think about when you're drafting petitions is most petitions, most cases get resolved by pleas, right? About 90% or more of the cases, the parent admits either abuse or neglect of some sort, and the court doesn't actually have to have a trial. And so that's an important thing for us to think about when we're writing petitions, and we'll talk a bit more about that later. Other questions or comments at this point? Okay. So if you want substance abuse to be part of the treatment plan, you have to allege substance abuse in the petition, and if it's an initial petition, you can't then negotiate that away, that allegation. If it's not a basis for the court taking jurisdiction, you're going to have a hard time getting the court to order services, and it may cause problems in terms of for the foundation of your case if at some point you may have to go to termination of parental rights and make that request. So let's see how a couple of examples of how petitions will frame the case. So very similar kind of thing to what Maggie was just talking about. So you have a child who comes into care for neglect. You know, parents maybe are using drugs or alcohol. They're not taking adequate care. They're not supervising their children appropriately. The children are being neglected. So the child comes into care, and then some period of time after the child's in care, placed maybe with a relative or in a foster home, the child discloses that there was sexual abuse in the home before he or she was removed. So you've got this new allegation, right? You're going to have a hard time these days getting the court to order sex offender treatment or sexual offender treatment for a parent, or to get paid for treatment for victimization on the child's part without having alleged this. So Section 19.1 of the Juvenile Code requires that the Protective Services investigate, and if they substantiate this new allegation of sexual abuse, to file a new petition. Another option, so that they could essentially file a second temporary custody petition that contains that new allegation of sexual abuse. And just as you start the case where the court has an adjudication based on a preponderance of the legally admissible evidence, you would look at that, the court would look at that new allegation in that same way. So we litigated the neglect case, the child was made a ward of the court, there's now a sexual abuse allegation, we're going to just do the same thing over again with the new allegation of sexual abuse. Then the dispositional options are all open to the court. Another way of doing that, let's imagine that Protective Services, when they investigate this new sexual abuse allegation, determines that there was sexual abuse and that sexual abuse involved penetration. What's the significance of that? Who knows? I'm sorry?
Mandatory petition.
It's a mandatory petition for permanent custody, right? So you've got to file a petition, and in that petition you must ask the court to terminate the parent's parental rights because of sexual abuse involving penetration. The court can look at this, just as we were talking about in Maggie's case, and you'd have a termination petition that would allege neglect, the original neglect, the parent's inability to maybe resolve that neglect problem. Let's say the neglect was as a result of substance abuse. The parent hasn't completed treatment. We've now substantiated sexual abuse involving penetration. Here's our new petition, mandatory petition for termination of parental rights. The court's going to look at the neglect and the failure to provide adequate housing, food, clothing, sheltering, those kinds of things, the substance abuse at one level of evidence, and it's going to look at the sexual abuse allegation with a higher level of evidence, clear and convincing evidence. Because it's a new allegation, it has to be proven just in the way you had to prove that initial neglect allegation, right? So it's got to be set out in your petition. You know, the court had jurisdiction based upon neglect. There was a new allegation of sexual abuse involving penetration. We are asking the court to take permanent, make a finding that the child was sexually abused and take permanent custody of this child as a result of that. So those things need to be set out in your petition. So you're not going to be able, for example, to require that a parent go to drug treatment unless that drug problem is alleged and either proven or admitted in your initial petition. You can't seek termination unless termination has been required in the petition, all right? So each step of the process, I want the court to take jurisdiction. I want the court to order mom's boyfriend to leave the home. I want the court to remove the children from the home. I want the court to terminate parental rights. Each thing that you want the court to do needs to be set out in your petition and specifically alleged, both in terms of a factual basis and in terms of a legal basis. So the question is, what happens if the court orders something that has not been alleged in the petition, right? So you don't allege in the petition substance abuse, but then the foster care worker requests and the court orders substance abuse treatment or assessments and so forth. Two things. One, the parent's lawyer, that provides a basis for that parent's lawyer to object to that treatment plan. If I were the parent's lawyer, I would argue to the court that there's no basis for that requirement. And you can't hold the parent to something that they've not been alleged to have done. So you've got a violation of what? Due process of law. We were not provided adequate notice of that. There were no allegations in the petition of that particular problem, and therefore you violated my client's constitutional rights in this case. So that's the immediate thing that can happen. Let's imagine the court orders it anyway. I think this is the problem, the judge thinks. The worker has said it's a problem. I'm going to order that you go through the substance abuse treatment. That provides an opportunity for the parent to appeal that case to a higher court to say, look, they violated our due process rights by not alleging any substance abuse in the petition, and then the court ordered that. The real rub is going to come down the line if you have to then later move for termination of parental rights, and the parent's been expected to do things that have never been proven. Presumably, when you file that termination petition, the court is going to require that new allegation of substance abuse now be proven. And how are they going to prove that? Well, they're going to probably prove that by maybe the drug screen results, if there have been drug screens. Maybe if the parent has admitted that he or she uses drugs or alcohol to a counselor or to an evaluator. All of that stuff could come in. Is that fair to the parent? Probably not, right? I mean, it's probably at a constitutional level unfair because you've not put that parent on notice. These are the reasons that we want to get involved in your family's life because you use drugs or because you use alcohol excessively, and therefore you can't take care of your children appropriately. So there's at least a colorable claim of a constitutional violation in that circumstance. So the question is, what do you do if foster care comes in and they do a more comprehensive evaluation of the family than was done by protective services, and you find new problems, right? Substance abuse or whatnot. What do you do about that circumstance? Well, I think filing a new petition is one option that you certainly have in that case, and it's probably the best option all the way around. There should be a petition filed or amended, because sometimes what happens is that the child will come into care on an emergency removal, and Protective Services has really not had much chance to investigate the case much at all. They just know that the child's been abandoned, found in the middle of the night or whatnot. They file an immediate petition, you get more information. Remember, you can amend a petition at any point in time as the ends of justice require. That's the legal standard. So pretty much any point in time you can amend the petition, and the court's going to be very liberal in letting you do that, as long as the parent has sufficient time to get ready to go to trial on that new petition. So the petition can be amended, or you could file a new petition which makes these new allegations, or you could, I suppose, refer the case back to Protective Services and ask them to investigate these new allegations, based upon the parent's admission and so forth. But it really does need to be put in a petition and then litigated. Okay, so the question is, when do you know when do you know that an amended petition is sufficient, or when do you know that you have to file a new petition? If you filed the initial petition and it's not gotten to adjudication, in other words, the parent hasn't pled or the court hasn't had a trial on it, you can amend it up to that point in time. If that petition has been litigated, then you need to go ahead and you're going to need to file a new petition that makes that new allegation. Right. Another option is to go back to the court and say to the court, mom admitted that she's she's using crack cocaine, or she's using whatever drug, methamphetamine. Mom admits this, we want to provide treatment for that. Now, if mom's willing to do that treatment and the court's willing to order it, you can proceed on that. The rub comes, or the problem is down the line, if you have to file a supplemental petition for termination, you're going to have to go back and prove that by legally admissible evidence. It's not a big deal in this case because mom has admitted it. But if mom denies it and you don't have clear evidence that it's the case, and sometimes it's less clear, like there were additional kinds of neglect. Or the baby was abused, but it was dad who abused rather than mom. Sometimes you'll get in that kind of circumstance. When it's less clear than the parent clearly admitting that they have the problem, that's when you're going to have problems when you have to file a new petition. Or you do it as a supplemental petition for termination, and you have to prove that new allegation by a higher degree of evidence. Yeah, so the question is, what do you do about it when each jurisdiction is a little different? And it's true that each jurisdiction will handle these in a little bit different way. Probably the best formal way to do it is to either amend your petition if it's not been litigated yet or adjudicated yet, or file a new petition with this new allegation. Mom is using drugs, dad is using alcohol, whatever it is.
Even after dispo?
Even after disposition, yep. You can file a new petition, and then the parent will either admit or deny that. And then it's clear then, again, what the parameters of the case are. Because these cases do get muddy because, there's an allegation made, you learn lots more about the family over time, you discover additional problems sometimes, and then what do you do about that? I mean, you're going to at some point have to litigate that, whether it's in a termination petition or in a second temporary custody petition. You're going to have to litigate that question at some point. Okay. So the question is, what might that hearing look like, that second hearing? When you file that first petition, the parent has a right to a jury trial of 6 citizens from the community. If the court already has jurisdiction of the child, the parent doesn't have a right to have a jury trial on that second petition. If you file the second petition, I mean, if it's as clear as mom admitted to the worker or to the treatment provider that she has using methamphetamine or crack or whatever it is, if it's that clear, the likelihood is you're going to get a plea arrangement out of that. The parent's going to tell, because the mom's statement can be used against her in the court, and then it's just a matter of process and going through that. So you're likely to get a plea in that circumstance more times than not. But if you do have to go to a trial, you don't have to, it's not a jury trial. The judge is going to hear it, or the referee is going to hear it in some counties, and they'll make the decision themselves. And if it's as clear as the parent admits that it happened, then or you've got positive drug screens, for example, then there's going to not really be any factual question about it, and more times than not, the parent's going to admit it to the court, and then you've got the problem resolved, and you can provide the treatment, and it forms the basis, the foundation for a termination down the line if that becomes necessary. Okay. Other questions? Okay. Because the petition frames the case that you're going to litigate and that you're going to live with for a year, as I like to say, it's important that you include in any petition every viable allegation that you have to make. And part of this goes back to Maggie's earlier question about what if you have an abuse allegation and a substance abuse allegation, and the substance abuse allegation gets deleted in exchange for the parent pleading to the child abuse allegation. One of the strategies that you have to think about when you're drafting a petition is that there's a negotiation process that's going to happen. Again, the vast majority of these cases are going to be resolved by some sort of a plea agreement between the parent and the agency. Parent's going to admit some aspects of the case. They're going to admit, some neglect. They're going to admit some abuse. And the case is not going to actually be tried. You're not going to actually have to prove it by legally admissible evidence, by calling witnesses and so forth. So you want to think about strategically putting in your petition every viable allegation you have to make, even if you don't think that it's all that critical. So you may have a case, our Jones case earlier, where the baby was a victim of shaken baby syndrome, and there's substance abuse in the family. But maybe the family also has a messy house, and maybe the family also has other, their gas has been turned off because they're not paying the bill. You want to put every one of those allegations in there, not because you're trying to be mean or nasty to the parent, but because it gives you room to negotiate, right? Better that you negotiate away an allegation that the parent has failed to provide, keep electricity or gas turned on in the house, than that you negotiate away a substance abuse allegation, right? Substance abuse is a real problem. I mean, it's substantively very problematic. And so you want to have things there, if they're available to you, where you have negotiation room. You can go to your prosecuting attorney or your attorney general or to the parent's lawyer in those counties where you kind of do this on yourself and you don't have good representation, to negotiate with them about, well, okay, we'll strike the dirty house stuff and we'll strike the failure to keep the gas on if mom will admit to the abuse and dad will admit to the substance abuse, right? So think about strategically putting everything in that petition that you think you can reasonably make out, even if it means that you kind of feel like you're being nasty or mean to the parent, all right? I've seen many, many cases where the workers say, yeah, well, that was all going on, but I didn't think it was all that important given the severity of the abuse and the substance abuse. That's true, it's not all that important, but it gives you lots of room to negotiate. And it will bring people in your direction in terms of the strategy of getting the case resolved. I wanted to talk just briefly about this notion that petitioning requires a shift in mindset. The state of Michigan hires people who are really good. I mean, you guys are smart, you're hardworking, and you're good and decent people, so you feel bad about doing this sometimes. I mean, I deal with a lot of workers, whether they be protective services workers or foster care workers, who really feel badly that they have to come to court, that they have to ask the court to remove children from their parents or to terminate parental rights. Very reluctant to do that. In part, that's because of your training in social work and in human services and so forth. But it's important that you understand that when you have to file a petition, you undergo a mindset shift. The thing that we were just talking about a moment ago, where you put every allegation in the petition, that feels really uncomfortable to some workers. I mean, some Some foster care and protective services workers feel very badly about that. But you have to understand that when you come to court in a legal proceeding, you're on a whole different playing field, if you will. I mean, it shifts, and you have to think about this in your mind as being a shift in your mindset. My focus is no longer keeping this child with mom and dad. My focus now is to get this child away from mom and dad. Or my focus is no longer trying to reunify this family. My focus is now terminating these parents' parental rights and placing this child in an adoptive home. So you have to sort of stop and shift your mindset and become an advocate, because that's what you become when you file the petition. Whether it's temporary custody or permanent custody, you have to become an advocate and kind of step out of your role as being an objective observer and an objective evaluator, and you become a kind of more subjective advocate for what your position is. So again, you move away from this idea of family preservation or reunification to a position of removal of the child or severing the parent-child relationship in order to make the child available for adoption. And I think that it's very critical that you understand that this requires this shift in mindset. So you're no longer going to be supportive of the parent, perhaps. Your job isn't to help this parent maintain the family. Your job now is to move into a position to be an adversary of the parent. Whenever you come to court, there is an adversarial relationship with the parent. And sometimes you will be even in an adversarial relationship with the child or the child's representative. I'm sure if you've done this for very long, you have experienced that in your work. You know, you're trying to help this kid, and this child is really not wanting your help, wants you to get out of their life, thinks you're causing them problems. Right? You're tearing up my family, you're taking my mom away from me, those kinds of things. And so you have to have this shift in mindset, and you have to become an advocate for what your position is. You know, if you've done your work, you've determined that the home is an unfit place for the children to be in, then you have to take your position, be strong in that position, and reflect that position in each of your in each of your dealings with the family. What we're going to do is we're going to take a little break, and then after the break, what I want you to do is to spend a few minutes reading this petition. I'll tell you that this is a petition that was actually filed in a case in Michigan, a case that I worked on as an attorney. And so what I want you to do is we're going to take a little break, and then after the break I'll have you look at the petition and basically critique it. What are the petition's strengths? What are the petition's weaknesses? Think about it both in terms of the substance, what substantively is alleged, and think about it in terms of the execution. Is it well written? Does it draw conclusions? If it does draw conclusions, are those the conclusions that you would draw? Are those conclusions well supported? Does it clearly articulate for the court, for the judge, for the parents, for the child, what you think happened in the case or what the petitioner thinks happened in the case? And is it clear what the petition is asking the court to do?